Hi, it's Mike DelSignore, Massachusetts OUI lawyer. In today's video, I want to talk about what's going to happen at your arraignment if you're charged with a second offense OUI. Second offense OUI comes in two types. One where your prior offense is within 10 years and one when they're outside of 10 years. So the penalties, the license loss will be different depending on how far apart your two OUIs are. If you took a breath test and you were over 0.08, you have a 30-day suspension under either scenario. The big difference is when you refuse a breathalyzer and your prior offenses are within 10 years, you got a hard, essentially 3-year license loss. The only way you're going to remove that if you're found not guilty and get a motion to reinstate. Now, theoretically, there is an appeal to the RMV on the refusal that's highly unlikely to be successful. So practically speaking, the only way to get your license back is a not guilty at trial. If you take a plea, you're looking at 3 years before you can get any type of license. After 3 years, you could potentially petition the Board of Appeals for a hardship. Now, if your offenses are outside of 10 years, then you have the ability to get back on the road with an interlock device. You can get what's called the Cahill resolution. I've talked about that in a lot of my videos. It's probably the most common question I get from other lawyers about what it is, what's required. So the Cahill resolution, sometimes referred to as a second chance first offense OUI resolution, allows you to get back on the road with an interlock device. You'll have an interlock for 5 years, a 12-hour license for 3 years plus 45 days, and then 2 additional years with the interlock. Now, if you took the breathalyzer and it's over 0.08, there are ways to exclude the test from evidence and to still win the case. But let's say you end up resolving a case or found guilty and there's a breath test. Then you have a 2-year suspension. If it's the Cahill type situation, you can try to get back on the road with an interlock sooner. If the court gives you the 24D program, 45-day license loss, then you can get back on the road much quicker and you only have 2 years of the interlock. If you're found, if you go to trial and you're found guilty, you can still get the Cahill resolution after trial. So if there's a breath test in the case and you lose the case and it's outside of 10 years, you could potentially get the Cahill resolution, get a 45-day license loss, get back on the road with an interlock device. But hopefully you can win the case. Now, last week in Brockton, I had a case. A client could have got a Cahill. We passed that up. Sometimes you can even get the Cahill after trial. Judge may not give it to you, so there are some risks. You want to talk about that with your lawyer. Can we still go to trial if we lose? I think most judges still probably would give a Cahill after trial. But in this case, the client was found not guilty. Next step, license reinstated by the judge. Now we're going to the RMV to have that implemented. So the client still has a ways to go to get back on the road, but almost there. The 3-year suspension has been vacated. Had there been a plea or any type of resolution, even with the so-called Cahill second chance first offender, you're looking at a breathalyzer in your car for 5 years. So the situation when you're charged with a second offense, there are different considerations to take into account. Getting back on the road versus the inconvenience of having a breath test versus having another conviction on your record for OUI. In most cases on a second offense, you're looking at a guilty finding entering. You generally won't get a quaff. Now, if your first OUI, there was a breathalyzer, you could potentially remove that and knock it down to a second. This week in Wareham District Court, we had a motion to vacate a prior case allowed. Client had a second offense within 10 years. Now that's gone. So now we have essentially 2 first offenses. So these are the different considerations when you charge a second offense. You see this can get complicated. There's a lot of moving parts here. But at your arraignment, you're going to enter not guilty, get a further date for pretrial. Generally speaking, when I talk to clients prior to arraignment, I'll go over all these variations. Then when we get the report, I have the specific information about the case, and then we can decide, hey, is this a case we want to fight, or is this a case you want to resolve? Hopefully you can fight the case. It's hard to prove an OUI beyond a reasonable doubt. It's a high standard of proof. The other thing to keep in mind, a judge or jury is not supposed to consider the fact you have a prior offense when judging the case. So don't assume you can't win the case because they're going to think you had a prior offense and know about it. I trust the judges in Massachusetts. That we have great judges here. They won't consider that. A jury won't even know it. So questions on an OUI second offense, what the process is at arraignment, feel free. Handle these cases all over Massachusetts. You can find plenty of reviews online. I've been doing this for a very long time. I've numerous videos as well. Call, text anytime. Mike DelSignore, 781-686-5924. My passion's helping people make the best decision possible when charged with an OUI offense.